Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to kind of circle back now around on the pistol brace rule. Now, we've spent a lot of time following various legal challenges and all the trials and tribulations of trying to get injunctive relief. And of course, we have all circled June 29th on our calendar as a huge day in the case of Mock v. Garland, which is going to be argued in front of the Fifth Circuit on that date. However, when it comes to trying to get rid of this horrible governmental overreach of a rule, maybe there's another way to skin the cat. Maybe we need to take a look at a different area of Second Amendment law and figure out how we can attack it from that front as well. And I think we may have found that case. So today, let's spend a few minutes and let's get you all educated and talk about how bump stocks could spell the end of ATF's pistol brace rule. Okay, so the case we're talking about today is the case of Guedes versus ATF. Now, the Firearms Policy Coalition is leading the charge here again, and they have filed for a writ of certiorari to the United States Supreme Court. What is a writ of certiorari? It's a fancy way of saying they have asked to be invited to the party. The Supreme Court will decide whether or not they get put on the guest list and get to argue before them next year. Now, this case originates out of the D.C. Circuit. This is a challenge to ATF's ban on bump stocks. We've done a few videos on that. Real quick history lesson. Horrible shooting 2018 in Las Vegas. Allegedly, bump stocks were used in committing an absolutely largest mass murder in the history of this country. It was then President Trump, despite the fact that there probably was all sorts of congressional will and ability to pass a ban on bump stocks, who himself decided to turn the ATF loose instead to rewrite the rules, rewrite the law, and make millions of Americans criminals overnight. Now, in this particular challenge in Guedes versus ATF, the D.C. Circuit Court actually threw the lawsuit out, saying, of course, the ATF has the right to regulate bump stocks and to define them as machine guns. Of course they do. But as we know, not everyone has been in agreement with that. In fact, the Fifth Circuit, in the matter of Cargill v. Garland, has found something quite opposite. They have found that the ATF's ban of bump stocks was unconstitutional and unlawful on multiple grounds. So, if you're keeping score at home, you know that the appellate court in D.C. as well as the 10th Circuit have said these bans are good. We also know that the 5th Circuit has said, hey, this ban is bad. And then the 6th Circuit has kind of come up with a middle ground where the rule is unenforceable. This sets up the perfect scenario for why the United States Supreme Court should accept review of this. Now, let me say this to anybody watching the video. Whether you absolutely think that bump stocks should have been banned, or you think that it is an absolute violation of your Second Amendment rights, for the purpose of what we're about to discuss here, neither of those positions matter. In fact, let's just take the position of those who believe that bump stocks should be banned, okay? And that is going to be based on your belief that nobody should be allowed to have a bump stock. Who needs a bump stock? It basically turns the firearm into an automatic weapon, and we could break down the technology and all of that. But let's just assume that in arguendo for now, okay? Here's what you need to be concerned about. Is if you want to ban something, if you want to redefine a criminal law that makes people felons, well, that's what Congress is for. And in fact, the most frustrating thing about what President Trump did is that when you take a look at the numbers in both chambers of Congress and you take a look at the political will and power that was there in the days following this horrific incident, the ability to have passed legislation was never more readily available than it was at that moment. And yet, for whatever reason, it was President Trump that decided to take the leash off the ATF. So you can be in total agreement with what ATF did, but you should be equally as concerned about how ATF did it, because they did it through rulemaking rather than passing laws. Does all of this sound familiar? Well, yeah, because it's an identical twin to what's happening right now with ATF's pistol brace rule. Now, the Cargill court, in striking down the bump stock ban, was very quick to point out a plain reading of the statutory language, paired with close considerations of the mechanics of semi-automatic firearms, reveals that a bump stock is excluded from the technical definition of machine gun set forth in the Gun Control Act and National Firearms Act. But even if that conclusion were incorrect, the rule of lenity would still require us to interpret the statute against imposing criminal liability. A rich legal tradition supports the well-known rule that penal laws are to be construed strictly. Chief Justice Marshall explained long ago, the rule is founded on the tenderness of the law for the rights of the individuals, and on the plain principle that the power of punishment is vested in the legislative, not in the judicial department. It is the legislature, not the court, which is to define a crime and ordain its punishment. But you see, this is exactly what ATF did, because overnight, sua sponte, they immediately made all of these devices unlawful, and they gave the people who owned them one of two choices: surrender or destroy. So now we have an unconstitutional taking. We are taking property from people without just compensation from government. That's one of many, many problems with the bump stock ban. The Cargill court also pointed out the government's regulation violates these principles. As an initial matter, it purports to allow ATF, rather than Congress, to set forth the scope of criminal prohibitions. Indeed, the government would outlaw bump stocks by administrative fiat, even though the very same agency routinely interpreted the ban on machine guns as not applying to the type of bump stocks at issue here. Nor can we say that the statutory definition unambiguously supports the government's interpretation. As noted above, we conclude that it unambiguously does not. But even if we are wrong, the statute is at least ambiguous in this regard. And if the statute is ambiguous, Congress must cure that ambiguity, not the federal courts. And also, if the statute is ambiguous, the court must adopt the definition offered by the defense under the rule of lenity. The court finally stated in Cargill, the definition of machine gun as set forth in the National Firearms Act and the Gun Control Act does not apply to bump stocks. And if there were any doubt as to this conclusion, we conclude that the statutory definition is ambiguous at the very least. The rule of lenity, therefore, compels us to construe the statute in Cargill's favor. Either way, we must reverse. But the big thing to take from this, it's not just the ambiguity in the statute. It's the fact that ATF had no statutory or constitutional duty or right to do what they did. This is a clear violation of the separation of powers. And what this case can do, Guedes versus ATF, is that it can actually get a once and for all definitive ruling from the United States Supreme Court as to the extent in which ATF can go. Now, we have been trying to read tea leaves and connect dots with how the United States Supreme Court has been boxing in the EPA lately. But what we really want to see, and this case has an opportunity to do exactly that, is we need to see this administrative rulemaking order rug pulled out from under the ATF. Listen, the case once again is Guedes versus ATF. We will put links for it down below in the description box and certainly keep you posted as to any updates. In the meantime, if any of you have any questions about this or anything else related to your Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.